So before we get to President Obama's search for a new justice and his criteria, let's talk about the big issues before the current court and whether the justices are, shall we say, plugged in enough to the technologies reshaping all of our lives. With me tonight, Democratic Congresswoman Debbie Wasserman Schultz of Florida, Rachel Brand, who was White House counsel and helped select federal judges during the George W. Bush administration, and in Boston, the Harvard Law School professor Charles Ogletree, who was a mentor for both Michelle and Barack Obama. Let me start with a simple question, Congresswoman, to you first. As you watch this from the Congress, is it relevant that the justices, they're not issued BlackBerries by the court? Many of them, most of them, still write their decisions out on long form. They don't have these pagers. Is that relevant in terms of, the president talks sometimes about an empathy test. Do they understand average Americans? Do you think they do?
I do. I think they surround themselves with people who, with clerks who help keep them informed, just like members of Congress surround ourselves with staff that have expertise. I don't think, per se, it's relevant whether or not Justice Scalia knows what a text message is. And what is important and is relevant is that in Congress, we're updating the laws to meet the technology that we're capable of utilizing today so that we can ensure that when the Supreme Court does have to rule, that the law is applicable to the facts. And that's what I think is incredibly important. But, you know, any policymaker or a justice on the Supreme Court isn't going to know everything. And it's important that they be able to surround themselves with people who can bring them up to speed on the issues that they're making decisions on.
Rachel, you were a clerk on this court. You obviously then also went into the executive branch. Two very different worlds when it comes to the use of technology. Is it your sense, as the Congresswoman says, do the justices, if they have to make these decisions, do they understand whether it's a working mother or a police officer whose hours may get extended by a sudden crime, may have to use that work device to send a personal note? Can they understand the challenge?
You know, they may not understand the ins and outs of the technology, but they'll know enough, they'll learn enough to decide the case. They're not going to be able, like the Congresswoman said, to experience the facts of every case that comes before them. When I clerked, there was a case about taxation of types of gambling in Iowa. They didn't have to go out and gamble on a riverboat in Iowa to decide that case. So they'll learn the facts, they'll learn the law, and they'll be able to make a decision.
And Professor Ogletree, in your sense, you have been a professor at Harvard Law School. Your students have included Barack Obama some time ago. You have lived this in the classroom, the evolution of technology in our lives. How important is it, if the court is the final arbiter of our society? There are 400 million users worldwide on Facebook. None of the current Supreme Court justices has a Facebook page. It's the third most populated country. If you took the Facebook universe, it's the third most populated country next to China and India. Do the justices need some technology training, some modern-day training, in your sense?
I don't think so. The Supreme Court is the Jack and Jill of all trades and really know a lot about a lot of topics. And I think about it, I'm not on Facebook, but I get information every day from people on Facebook. I think this court, in any court that we've seen, is very smart in hiring people like law clerks who have a lot of contact. They'll read information, they'll be well prepared. I don't think you'll see even an ounce of lack of knowledge about what to do. And I think they'll do the right thing in analyzing these cases about tweeting, Twitters, about text messages, about email. They know what the law requires, what the Constitution permits. I don't think there'll be any barrier to those decisions.
Rachel, when you look at that particular case, it's called Ontario versus Kwan. Is it a groundbreaking privacy case? There's a written policy the police officers get. They're essentially told the government owns this, and anything you do on it is by the government. But their take is that, you know, they've also been told in the rush of their job, you can do so, you know, if you have to send a family message, and they want that to be private. Is it groundbreaking, or is it pretty straightforward?
It'll all depend on how the court decides it. If they decide it expansively, it could be groundbreaking, but not necessarily. It really depends on where they decide to go.
And in terms of the Congress often reacts to what the court says. It says, we don't like that, or we do like that, and we're going to write statutes. How much of that comes up in your own life, and then you take it to work in the Congress in the terms of, as technology changes our lives, how many laws do you think you need to go back into and say, look, this is different, we do that differently now?
Well, I mean, as a representative, I can tell you just the way I look at things like that is it's very different. When I type an email on my BlackBerry to my child's teacher, that should be treated, I think, very differently than when I have a correspondence with a colleague or with a member of my staff. They all happen on the same technological device. The question is whether or not my child's teacher's email is private, and I mean, I think that's an appropriate area for us to legislate. I know as a mom, I would want to make sure that my personal communication about my own child would remain private.
What is your sense, Professor Ogletree, of the biggest issue before this current court? We're going to talk in a minute about the president's choice in trying to reshape the court. But as you look at this current court, the privacy decisions, the big First Amendment decisions this court has made in expanding it, what do you look for between now and the end of the term that you think is a significant opportunity for this court to perhaps put its last imprint on American society before it's changed?
I think the big issue is still going to be national security. You know, how much power should the executive branch have? How much power does Congress have? And this court, with conservative majority, has been pretty clear about giving the executive branch and Congress some discretion to make sure things go forward. So I think that's going to be the big issue, even though there'll be a lot of cases like the animal cruelty case, this case about technology and privacy. But I think the real issue is going to be how far can the government go in protecting its citizens without violating the rights of individuals. I think that's going to be the recurring issue for this court and the next as well.
We'll continue this conversation in a moment, including comparing what the president said today about abortion to what other presidents said in the past. But before we take a break, here's our look behind the numbers on Wall Street today. The Dow Industrials closed slightly higher today. The real headline, though, is the combined first quarter profits of the nation's 6 biggest banks, $18.7 billion with a B dollars in just 3 months.